Hello and welcome. Welcome. And the camera is not the right camera. The other camera is not on. How are you all? This is what happens when you decide to do something off the cuff without much, not much thought. So this camera is not going to work at the moment. Hope you're all well. So if you have been following my channel, you would know that I shared about, let me just grab the correct, and my microphone's not here either. Interesting. Hope you can hear me all right. That's better. You would know that I shared just recently that Australia has a travel ban in place that finishes on the 15th. And there was a gentleman that decided to sue the government and try and get that overturned. Well, the court decision came in, the judge threw it out, and I've got the documents. So I thought we'd have a look at the documents. It's really quite interesting to see how they all work. So let's get started. Hello, everybody. Hello, Kino. Hello, Laura. Yes, I know. And this is a surprise live as well. So I'm actually not very well. I actually have to go have a COVID test just because I've got cold symptoms. So, so this is the affidavit. So I did a video just recently with the original documentation. So this is now the final submission with the judge's ruling. So this is an affidavit. This affidavit, not our friends Electric. All right. So this is his affidavit. This is being filed on behalf of the applicant, and it's prepared by a lawyer. So it says, I am authorized to make this affidavit on behalf of the applicant's behalf in relation to his originating application. Oh, hi, Misty. My last review says it's age. Yes, it's only because it's got adult content in it, Misty. That's why. Hi, Jean. Except where otherwise indicate, I make this affidavit based on my own knowledge and belief. I have previously affirmed one other affidavit at 4 p.m. at 4:22 p.m. on the 6th of May. The solicitor for the respondent, Mr. Jonathan Hutton, provided me a whole bundle of documents labelled bundle of documents before the Minister of Health and Aged Care when making the human biosecurity emergency human coronavirus with pandemic potential emergency requirements high-risk travel pause determination. A copy of the bundle is annexed to this affidavit. At 6:34 p.m. on the 6th of May 2021, Ms. Kira Peacock of Mark Lawyers emailed Mr. Hutton, so a copy of the letter. 7th of May, Mr. Hutton sent an email back with a ministerial submission. The attachments, due to the present working conditions resulting from COVID-19, this affidavit has been witnessed electronically. So at the moment, Sydney is under has a few restrictions at the moment. So this is Annex 1. So this is the bundle. So we are now going to find out the behind the scenes of how or what the process that occurs or what the process was for the government to make a decision on the travel ban or the travel pause. So remember, the 2nd of May, the Australian government said all travel from India into Australia is banned until the 15th. So we're now going to see all of this. So this is the pack. So this is how they make a determination. So they have this to Mr. Hunt, critical date 2nd of May, to manage people travelling into Australia who've been to India in the previous 14 days. Note advice from the CM, Chief Medical Officer, attached. So he would circle whether he noted, indicate by circling whether you are satisfied. So he's got to read all of these. He's got to state whether he's satisfied, yes or no. Then he has to indicate whether he's satisfied that requirement for a person who's entered in India, who has been in India within 14 days not to enter Australian territory. At a landing place is necessary to prevent. No, I think it's a different Gary Newman. So he has to. He would circle yes, no, or please discuss. Then if he signed yes to 2 and 3, he'd have to sign and date it. He'd click sign and dated or not signed, and then if he approved it, he would circle approve. Then he would sign it, date it, whether there was a media release. So this bundle is what determines how they go about that process. So this submission seeks your agreement to determine an emergency requirement that a person must not enter Australia territory if they've been in India within 14 days before the day their scheduled flight commenced, subject to limited exemptions. The emergency requirement, if made, will be temporary and will commence the 3rd of May 2021 and automatically repealed on the 15th of May 2021. If made, this requirement will be the first time that the Biosecurity Act 2015 has been used to prevent Australian citizens and permanent residents from entering Australia. This may result in hardship for Australian citizens and permanent residents living in India, including difficulties in accessing saving life medical care through Australia. Joanne, this is your country. You would have to tell me whether you are for or against this. I don't know, I'm afraid. Well, at the moment, Jean, we've just had another case. We've just had a case. He did 14, came back from India in April, did 14 days quarantine in South Australia, has travelled around Victoria and has now tested positive. So everyone's on high alert. New South Wales is on high alert. I actually am for it, the temporary pause. So it's not a permanent ban. It was just a temporary pause. And I'm actually for it. I agree with it. But this man is in India and he wants to get home. I understand Jeff Sissons is stuck in his... Well, that is also true. That's also a good point. And he did actually travel while India, I think he travelled in April, I think. So, yeah, look, people have been mixed. There's been lots of mixed reactions over it as well. So the judge threw it out. So the judge rejected it and has taken the side of the government. But it was tried in court and the government has won. But I think it's really good, though, Jean, to have a look at all of this stuff, because in order to make a decision, but the US would never close their borders, the restrictions. Look, there are still exemptions in place. There are still certain people that still can get in and out. I know the US has closed their borders, but was still open for citizens and residents, where Australia's just gone, nah, we can't let anybody in. Our hotel quarantine at the moment is, our hotel quarantine system at the moment is struggling. And this is why they've done this, because it's struggling. And you'll see here, hello, Alberta, you'll see here shortly that one of the recommendations or one of the concerns is the more positive cases that end up in hotel quarantine, the more likely it is that it will get out into the community. And if the Indian strain gets out into the community, I don't know what's going to happen. So there is that fear. So the chief medical officer, and he is the one that advises the government, has designated India as high risk. This submission seeks that you exercise your power under Section 477 of the Act to determine an emergency requirement that a person not enter Australia territory if they've been to India within 14 days before the day of their scheduled flight commenced, subject to limited exemptions, noting that many of the connecting international air services from Australia from India have already been paused. Commencing the requirements from 12:01, the 3rd of May is appropriate and provides adequate messaging around the new requirements. This view is supported by the CMO. So this goes through what they have to be satisfied. So this then gives him a checklist. So he has to be satisfied that it is going to be effective, that it's appropriate, that it is not going to be any more or less restrictive or intrusive than is required, and that it is for as long as possible. So that's what this bit says. So again, this is the Act would require a person not enter Australian territory at a landing place if the person has been in India within 14 days before the day of their scheduled flight commenced. Unfortunately, India is high risk. Australia is not allowing any flights from India for a while. I feel for them for sure. Exactly. So high risk. So here's the fact. So it's saying that there have been a high COVID-19 positivity rates in persons returning to Australia from India. Since late March 2021, there's been a sharp increase in the number and proportion of overseas acquired cases that were reported as acquiring their infection in India. Over 50% of overseas acquired cases since April 2021 were acquired in India. The integrity of hotel quarantine arrangements are put under strain as the number of overseas acquired cases in quarantine increases. The potential for local transmission of COVID-19 within the facility and to the community increases with the higher case rates among international arrivals managed in mandatory quarantine conditions. Determination will also act as a deterrent to limit the number of people in quarantine. So again, it's a very detailed document as to so it's for a travel pause. Based on the above, it is open to you to be satisfied that the proposed requirement that the person not enter Australian territory at a landing place when they've been in India the previous 14 days is appropriate and adapted to ensure the hotel quarantine arrangements are not overwhelmed and that COVID-19 does not enter the broader Australia community. And I think this is the the fear. Because with Victoria, where I live, we had 73 days without a positive COVID transmission, community transmission, and we've had one case, and so now everybody. Yes, that's right. The quarantine was originally 28 days. Information period could be as long as 28 days. I thought it's funny. A lot of the cases are coming out between day 14 and 21 at the moment too. So, yeah. Look, we're not in lockdown yet. At the moment, everybody that's in the network. Has tested negative, but so essentially what they've done in Victoria is they've put it as tier 1, tier 2, tier 3. Tier 3 is you check for symptoms, you get tested if you've got symptoms. Tier 2 is you have to isolate and get tested, and if you get a negative test, you can go about your business. And tier 1 is you have to do 14 days quarantine. Right, so the high-risk country accompanying travel pause are no more restrictive or intrusive than is required in the circumstances. The manner in which the high-risk country incoming travel pause emergency requirements are to be applied is no more restrictive or intrusive than is required in the circumstances. So we've got that. So the requirements are proposed to you to be enforced until the 15th of May. The CMO, in his letter to you dated the 30th of April 2021, recommends that the travel restrictions be in place for a limited duration. A review of whether the requirements continue to be necessary will take place before the requirements are repealed. This will ensure the pause only applies for as long as possible. So they're going to review it. I'm sort of hoping that it gets extended a little bit longer because so this is public interest immunity. So there is some stuff we're not going to get. So legislation requirements, what's going to happen with, and then who he's consulted. Consultant consultation that has occurred with the Border Force, Department of Foreign Affairs and Trade, Department of Prime Minister and Cabinet, the Office of Parliamentary Counsel, the Australian Government Solicitor. The Indian strain is a lot harsher. It's a lot more deadly. So again, in my last video, I went through the letter from the Chief Medical Officer, sorry. So this is this letter here that was recommended and why it was recommended. And then the exemptions. So a member of a crew of an aircraft, a worker associated with safety maintenance of an aircraft, person engaged in day-to-day conduct of inbound, outbound freight, a person including a member of the Australian Defence Forces travelling on official government business, a person who is an immediate family member of a person mentioned above, a diplomat on a 995 visa, and a member of the Australian Medical Assistance Team. So that's from the Chief Medical Officer. But this is then this is what he would sign. A copy of what he would sign to say that, you know, this would happen. And then this is all the legal stuff. This is the official documentation that goes with it. So it says, you know, so this is like, they've got their definitions. Relevant international flight means a flight that commences outside Australian territory and is intended to arrive at a landing place in Australian territory, for which the scheduled departure time is at or after 12:01 a.m. 3rd of May 2021. That is not an Australian government facilitated flight and is not an emergency medical evacuation flight, and it says it's going to be repealed. So this is just like all the government stuff now. So the requirements, so the exemptions again. An explanatory statement. So sometimes this is quite often read in Parliament to explain what it's about. So this is like the short version of it. So it says, on the basis of the above, the Minister for Health is satisfied that the determination is necessary to prevent or control further entry into the emergence, establishment or spread of COVID-19 into any part of Australia. All right. And again, some history and some background on that. And then the emergency requirements for that. The attachment. Oops. We skipped a few pages, sorry. I just skipped a page. Right. So then we've got the media release. So they've got the draft media release as to how it was going to go. Well, that's the interesting thing, Bo, is that it was recommended from the 3rd of May to the 15th. I don't think anything's changed. I think if anything, it's gotten worse. So I would like to think that it would be extended, but I don't know. I really don't know. So I mean, part of it was to give hotel quarantine a bit of a break. Initially, it was because there were breaches in New South Wales and Western Australia. Well, now we've got South Australia's had an issue. So this is the letter written from the solicitors. So they've written here to say the bundle contains ministerial submissions dated 30th of April 2021. There are no signatures or annotations, so they want to know, and if they want to know whether he made any changes to them. So then we get So this is the email from the Australian government lawyer. And again, a lot of it's blocked out. However, here it is. So this is, we've got here where he's circled. And yes, signed and dated, and he's approved it, and his signature, and it's been dated. So, and that is the thing to say it's been filed. So that was the affidavit. There's a lot of documents. So then we've got submission. We've got another applicant. So we've got all of this stuff here. And then before we get to the order, so let's look at the affidavit of, so then we've got submissions here. So these were written submissions. So this is their argument to the court. There's 17 pages. So it says, on the 30th of April 2021, the Minister for Health and Aged Care, the Minister, made a determination known as the Human Biosecurity Emergency, Human Coronavirus with Pandemic Potential, Emergency Requirements, High Risk Country Travel Pause Determination 2021, named as the determination pursuant to Section 4771 of the Biosecurity Act of 2015. The determination prohibited entry into Australia by a passenger on an aircraft who had been in India in the preceding 14 days. By Section 479 of the Act, a person who fails to comply will commit an offence. The determination included certain exemptions defined by Category S7 and provided for its own repeal at the start of 15th of May 2021. The applicant challenges the validity of the determination on a number of grounds. By orders of the Federal Court made on the 5th of May, the present hearing concerns only prayers 1 and 2 of the originating application filed 5th of May. So here are their issues. Did the Minister fail to comply with the statutory preconditions to making a determination in Section 477? As a matter of statutory construction, does the determination operate extraterritorially, and does Section 477 displace the presumption against laws having extraterritorial effect? Whether there exists a fundamental common law right to re-enter Australia that can be abrogated by clear words or necessary intendment, and whether the Act demonstrates a clear legislative intent. So here's our background. Hello, Poppy Seeds. How are you? I know this case, but still went Gary Newman cards. I know. Oh, dear. Oh. I don't think many were really surprised by the outcome of this case. So, Poppy, here's a question for you. Do you think they're going to extend it, considering now that we've got the case from South Australia that's happened in Victoria? Do you think it's going to get extended? Or, because it does say it's going to be reviewed prior to repeal. All right. So here's our background, and we have footnotes, but they're not sassy. So the applicant is an Australian citizen who is 73 years of age. So it says, see extra affidavit, Michael Bradley. By reason of his age, as a matter of jurisdictional notice, he's high risk of serious illness or death if he contracts COVID-19. He departed Australia for India in March 2020. Before the Minister imposed a travel ban on departing Australia, disembarking in Bengaluru, I can't pronounce it, India, on the 6th of March 2020. He has been in India ever since and remains largely indoors for fears of contracting COVID-19. The applicant was permitted by his visa to remain in India for up to 180 days until September 2020. In November 2020, when it appeared the airlines were recommencing services, the applicant booked a flight to Australia. That flight was later cancelled. The applicant presently wants to fly back to Australia. He has considered travelling via a third country to do so, but he would be committing an offence under the Act. Now, Poppy Seed says, I want to say no because of the political backlash and it's an election year. Is it really an election year, Poppy? I think the commercial and maybe military. Yeah. Bo, that is the bane of my existence, quarantine. Yeah. I've been calling it out for ages, but the states at the moment have been given the responsibility and they're using hotels and it's not effective. So now we're at the determination. The determination was made by the Minister on the 30th of April. According to publicly aware material, Minister received advice from the Chief Medical Officer, Mr. Paul Kelly, by letter dated the 30th of April. By Section 544 of the Act, the person who occupies or is acting in the role of Chief Medical Officer is also the Director of Human Biosecurity. The purpose of the Act is, among other things, to provide for managing risk of contagion of a listed human disease or risk of listed human diseases entering emerging, establishing themselves or spreading into an Australian territory. Well, Jean, I'm getting, technically election year is on or before, but still. So I'm having a COVID test today because I've got some symptoms that I think it's just a cold, and I've also called in sick, so I'm actually not leaving my house other than to get my COVID test from now until at least the weekend, because I've spoken to my work boss and we've just said, let's not risk it, particularly now with all the positive, with all the hot spots and everything, and the fact that there's been a case in Victoria. So, we're just doing that. And I've rung my doctor and spoken to my doctor as well, and they said, yep, that's ruled out. He's probably just a cold, and all going well. So, yes. Well, and the other thing is, Jean, I have to admit, I've got a bit complacent. So it's a really good reminder about not being complacent. All right. So Australian territory is defined to include Australia and the airspace over Australia. So there you go. I learned something. The airspace over Australia is also Australia. The Chief Medical Officer, in his role as Director of Human Biosecurity, may determine that a human disease is a listed human disease if he considers that he may be communicable and cause such significant harm to human health. Chapter 2 of the Act confers powers on the Minister to determine requirements in respect of individuals to prevent entry, emergence, establishment or spread of a listed human disease. So C44, 51, 60, 87, 107. Chapter 8 of the Act, by contrast, provides special powers for dealing with biosecurity emergencies of national significance. Of present relevance is Part 2 of Chapter 8, which contains Section 477. Provides special powers for dealing with emergencies involving threat or harm to human health on a nationally significant scale. Section 475 provides that the Governor-General may declare that a human biosecurity emergency exists if the Minister is satisfied that a listed human disease is posing a severe immediate threat or is causing harm to human health on a national significant scale, and that the declaration is necessary to prevent or control the disease in Australia. The declaration must state the period of time for which it applies and be no longer than 3 months, and although it can be extended under Section 476. By Section 474, a power under Part 2 of Chapter 8 may only be exercised by the Minister personally. Section 477 provides the Minister with a wide power to determine any requirement that he or she is satisfied is necessary to prevent, control the entry into emergence, establishment or spread of the declaration listed human disease in Australia, or to prevent or control the spread to another country. Section 477(2) provides the determination will not be subject to parliamentary disallowance under Section 42 of the Legislation Act. 4773 provides a non-exhaustive list of requirements the Minister may determine. Section 4774 sets out the statutory preconditions to making a declaration. Section 4775 ensures the primacy of the determination over any provision of Australian law. Section 4791 states a person must comply with a requirement determined under subsection 4771 that applies to that person. Section 4792 makes it an offence to engage in conduct that contravenes the requirement and imposes a penalty of 5 years imprisonment or 300 penalty units. The determination provides in Section 6 as follows: a person who is a passenger of an aircraft or on a relevant international flight must not enter Australian territory at a landing place if the person had been in India within 14 days before the day the flight was scheduled to commence, unless an exemption set out in Section 7 applies to the person. Section 4 of the determination defines a relevant international flight as a flight that commences outside Australian territory and is intended to arrive at a landing place in the Australian territory. I think they are, Jean. I think the embassy is trying to help people. Australian territory is defined in Section 12(2)(b) to include Australia and the airspace over Australia. Passenger is defined in Section 9 of the Act as a person who is lawfully entitled to be on board the aircraft other than its crew. Landing place in Section 9 as any place where the aircraft can land, including a land area of water. Coronavirus is a listed disease and human biosecurity emergency is declared. To the best of the applicant's knowledge, on the 21st of January 2020, Director of Human Biosecurity, Professor Murphy, made the Biosecurity Amendment Determination 2020, which determined that human coronavirus with pandemic potential was a listed human disease. Key is negative pressure airflow stopping spread of cancer in third head chosen. Yes, I know. That's right, Bo. That's what we're discovering. Hydro just joining, so I got to see you at the beginning and now end of my day. Good luck. Thank you, Dee. I know. I just jumped on. I was going to record it and I thought, you know what? And it was interesting because I rang my, I emailed one of my uni lecturers and I had to send him something and I said, oh, look, I'm having to have a COVID test and, you know, and this and that. And he's going to come back and he goes, oh, don't worry about it. Just rest up. And I've gone, oh, cool. I've got to. So I thought, what am I going to do? Oh, I was going to film and then thought, oh, well, I'll just go live. It's much more fun doing these documents live. So, pursuant to Section 475, on the 18th of March, the Governor-General declared that a human biosecurity emergency exists in relation to listed human disease, and that's the declaration. Pursuant to Section 476, the emergency declaration appears to have been extended, most recently on the 2nd of March 2021, so that the emergency period continues until the June 17, 2021. Now, I didn't know that either, so that's also very interesting. Oh, thank you, Dee. On the applicant's present understanding, therefore, it appears the jurisdictional, there's that word, precondition in Section 475 of the Act was satisfied at the time the determination was made. It is appropriate to turn first whether the minister was complied with the statutory preconditions in Section 477. They're trying to say that he didn't comply with the preconditions. So there is uncertainty as to whether the basis upon which a court will review delegated legislation is completely coextensive with the grounds of review of administrative decisions. So now we've got all this law stuff down here. There is no doubt, however, that the court may declare delegated legislation invalid on the basis that the exercise of the statutory power to make the delegated legislation was for an improper purpose, and that there is an inconsistency or repugnancy with the empowering statute, and or because its effect is unreasonable, that it cannot be regarded as falling within the contemplation of legislature. The latter has recently been held by this court to incorporate notions of legal unreasonableness and irrationality. So down here. Hello, Kim. I promise you I'm going to be better behaved than I was last time I was live, hey? In absence of direct evidence, the basis on which the state of mind was reached will generally be inferred by reference. The power conferred under Section 477 may only be exercised by the minister personally. It may only be exercised where the minister has determined that the delegated legislation is necessary for one of the purposes in section 4771A to C and has reached the requisite state of satisfaction of the matters in section 4774. In the absence of direct evidence, the basis on which the state of mind was reached will generally be inferred by reference to material that was before the minister at the time of the decision. The minister is entitled in that regard to rely on the summary or brief provided by their department to adopt the reasons they're set out as the basis for their decisions, although it is then adopted with virtues and foibles. Why do I like these big words? Equally, it is open to a minister to take into account political considerations when exercising legislative power to make delegated legislation. Yeah. Hi, Leah. Or Lee, sorry. As to drawing of inferences in respect to the decision-making and the time required for a minister to consider the relevant material, the forecourt explained in Chet Kuti versus Minister for Immigration and Border Protection at 99 that evidence in respect for how long the minister in fact had the material before him can be relevant to the court's assessment. The minister has now produced materials said to have been before him at the time of his decision. 15. It says, see second Bradley affidavit at blank. Blank. The following observations must be made in respect of the material. All the legal documents for them to say because I say so. Yes, Jean, I know. But the lawyers actually worked for free. So the lawyers for this Gary Newman worked pro bono. So it still costs money because the government's had to defend itself. So I guess the taxpayers are the losers here, I guess. First, nowhere in the material is that yes, Kim, the judge threw the case out. Any alteration or annotation by the minister to the component paragraphs of the ministerial submission document MS-21 or the material before him, other than the indication of his decisions on the recommended page. Second, while the minister's submission purports to summarise and quote from the advice from the Chief Medical Officer and attach the same advice, certain of these quotes do not appear in the advice itself. Most significantly, submissions at 16 suggest that the advice include the statement that the requirements will contribute significantly to protecting the Australian community and health system. That phrase is not found in the advice. There's nothing to suggest that the minister was alive to this discrepancy, which would only be apparent by reading the underlying material. Third, the ministerial submission itself does not include any reference to the potential criminal sanctions attaching to the determination made under Section 477, although they were referred to in the Chief Medical Officer's advice. Fourth, the Chief Medical Officer's advice does not address the criminal sanctions nor purport benefit possibly gained by them, other than the bare reference to them, nor does it address the domestic public health risks associated with possibly COVID-positive persons being detained or taken into remand on suspicions of breaching the determination. And yet, despite those apparent admissions, and although unnecessary, the Chief Medical Officer expresses his own satisfaction that it was necessary to impose an offence. Fifth, the Chief Medical Officer's advice makes reference to the direct flight ban that had only recently been introduced, saying, I note that although Australia has already implemented a ban on direct flights from India, flights through transit hubs continue to provide an avenue for individuals who have recently been in India to enter Australia. The advice does not consider at all the effect that the direct flight ban upon the issues said to lie at the heart of the proposed determination. It contains no evidence or analysis of the quantity of Australian citizens or permanent residents then present in India who could have or were likely to have taken advantage of a third country transit route. No evidence or analysis of the decrease in COVID-positive arrivals as a result of the flight ban and any consequential reduction in pressures upon the quarantine system. And no health advice on the marginal benefit of the extraordinary step of imposing a criminal sanction on re-entry in light of the direct flight ban. Nor did they offer any consideration the effect of the flight bans had been imposed by other governments. Part of the salient facts relevant to the circumstances in Section 44D. 6. The ministerial submission is comprised primarily of conclusionary statements of matters to be satisfied in sections 477(1) and 4, and selective quotes from the Chief Medical Officer's advice. 7th, the historical Solicitor General's advices, over which privilege is claimed, are both dated March and November 2020. No inference could arise that they assisted in the minister's reaching his state of satisfaction about the determination. So we've not seen what the Solicitor General has recommended. Finally, there is no evidence as to the length of time such material was considered, but it must have been less than a day, given the Chief Medical Officer's advice and the ministerial submission are each dated the 30th of April 2021, the same day as the determination. To summarise, there is no evidence that the minister read or engaged with the ministerial submission. Even if the minister did consider the ministerial submission, that document made no reference to the imposition of criminal penalty. It would be therefore followed he failed to be satisfied with the requirement that the requirement was likely to be effective in or contribute to, not whether it was appropriate and adapted to the purpose of determination. Even if, which is not admitted, the minister went further and read the Chief Medical Officer's advice, that document does not provide health advice on either A, the existence of any marginal health benefit from criminalising re-entry to India in light of underlying circumstances of an existing flight ban from India, nor 2, health advice on the effect of imposing criminal offence, a domestic health risk consequent upon taking someone into remand if they failed to comply and forcible arrest was required. So what do you reckon of their arguments so far? I know probably it's a lot of gobbledygook. Oh, no. How do blind people... Oh, no. How do blind people... I'm most legally blind and walked around without my glasses. Everything I can't unchucked mess. Oh, no. So they're saying... what they're saying is that if he got the statements on the 30th of April and he signed them on the 30th of April, that he probably didn't take into a lot of consideration. So... Further, the CMO does not purport to be giving any other form of non-health related advice on matters, including the appropriate of criminal penalty, the existence of legislative powers to restrict entry of aliens as opposed to citizens, or the relative numbers of aliens as opposed to citizens seeking entry into Australia. Each of these matters would have been appropriate for the minister to consider as part of reaching satisfaction. The restriction was no more restrictive or intrusive than is required in Section 4774C. Taken together, these matters reveal an absence of sufficient material from which a reasonable state of satisfaction could be reached to exercise the power in Section 477. By ignoring the salient consequence of making a determination, the minister's decision falls outside the decisional freedom afforded to him. The court also thus finds that the making of the determination exceeded the power granted to the minister and declare the determination invalid. So now we're going to look at the statutory construction. The task for the court in reviewing the legislation is first to determine the meaning of the words used in the Act of Parliament, second to determine the meaning of the subordinate legislation itself, and finally to decide whether the determination complies with the description. Here we go. The scope of the provision that empowers delegated legislation that are necessary or convenient or similar phrases was explained in Shanahan and Scott. Again, we've got legal documents. Such a power does not enable the authority by regulations to extend the scope or general operation of the enactment, but is strictly ancillary. It will authorize the provision of the subsidiary means of carrying into effect which is enacted in the statute itself and will cover what is incidental to the execution of its specific provisions. But such a power will not support an attempt to widen the purposes of the Act, to add new and different means of carrying them out to or depart from, vary the plan which the legislation has adopted to attain its ends. The court in Shanahan also referred to Isaac J's reasoning in Carbines versus Powell, to the effect that delegated legislation could be complement but not supplement the granted power. So again, more legal stuff. And what about the unaccompanied minors? Well, that's the thing. Interestingly, I think they said there's 170 unaccompanied minors stuck in India. That rather bothers me at the moment, because I don't know that I'd put my unaccompanied minor on a flight to India anyway. But that's just me. So anyway, so here we go. Now they're going to argue the scope of the legislation. The ambit of the authorising power may vary depending on the character of the statute and the nature of its provisions it contains. So in the present case, the applicant necessarily accepts the Section 4771 of the Act confers a wide power to determine requirements that are necessary to prevent and control entry of a human disease into Australia in the circumstance of a human biosecurity emergency of national significance. The power to control, when read with the word regulate, has been treated as permitting something less than prohibiting. However, prevent has also been held to be equivalent to prohibit in certain circumstances. But to the extent that a power of prevention has been conferred, it should be construed narrowly and must be appropriately and proportionately tied to preventing or controlling the entry of the listed human disease. This is where the broad conferral section in 4771 must be read harmoniously with the non-exhaustive and indicative examples of requirements that can be imposed in Section 4773. In this regard, Section 4773 may be seen to clarify types of determinations, where the legislator specifically contemplated might be made under the section. The first of those, Section 4773A, refers only to requirements on entry, but it does not expressively refer to a prohibition, restriction, or prevention on entry as considered in Section E below. That is consistent with the conclusion that the legislator did not intend to abrogate the citizen's common law right of re-entry. The conclusion, in turn, informs the breadth of Section 4771. It cannot contradict the position reflected in 3. The second example, Section 4773, can provide no assistance to the minister in locating a statutory source of authority for the determination. That subsection indicates the minister has the power to make requirements that restricts or prevent movement of persons, goods, or conveyances in or between specified places. The applicant's case is that Section 4773B must be read as an authorising prevention of movement only within the Commonwealth, and that the determination on its term applies to restrict movement of people while they are overseas. Notably, specified places is also used in Sections 4773A and C in respect of matters over which the minister could only exercise control within Australia. It would offend the principles of statutory construction for the term specified places to have two materially different meanings in different subparagraphs in one provision. As pleaded in Prayer 1B2, Section 477 has no extraterritorial effect if it is to be argued on the minister's case that the determination properly construed is an example of a requirement restricting or preventing movement between specified places. That can only be understood as movement between Australia and a place overseas. The determination purports to operate in respect of a person, no, all people, not just citizens, who is a passenger of an aircraft on a relevant international flight, and requires that they must not enter Australia territory at a landing place. A person can only be a passenger by boarding a relevant international flight as defined in places other than Australia. There is both common law and statutory presumption that the legislation will not have extraterritorial effect. It sounds like we're talking about, I love the word aliens and extraterritorial, it sounds like we're watching like E.T. or something, hey? And the references to the Commonwealth Act are things to and matters in and of the Commonwealth, subject to any contrary intention. The common law presumption arises in part as a principle of commodity and similar to the principle of legality, as considered below in section E. Yeah, the judge upheld the government's decision. Proceeds on the basis that absent clear words or necessary implication, statutes are considered on the basis that they do not apply to persons and matters outside the territory. There is talk of them looking to appeal, but considering that it ends on Saturday, is it worth it? I don't think it's worth it. The statutory presumption, I mean, if I was the guy, I would have my ticket booked to fly out on the 15th. That's just me. The statutory presumption, which reflects the earlier common law presumption, is found in section 21 of the Act's Interpretation Act of 1901 in the following terms. In any act, references to localities, jurisdictions, and other matters and all things shall be construed as references such as localities, jurisdiction, and other matters and things in and of the Commonwealth. So I think they're saying that the government doesn't have jurisdiction for stuff overseas. I think they're trying to argue jurisdiction. Section 2.2 of the Acts. Okay, my understanding is that the constitutional argument hasn't been addressed, only the scope of the Biosecurity Act. So, all right, right. Yeah, I haven't seen anything to see that, like, there's nothing listed to say that they're taking up the other issues. Section 2.2 of the Act's Interpretation Act provides that the application of this Act or provision of this Act to an Act or provision of an Act is subject to contrary intention. In DJR versus Commissioner for Victim Rights, explained the effect of similar state provision in Section 12. The effect of Section 12 is not to expand the operation of New South Wales legislation so that it extends to all matters and all things with a nexus with New South Wales. Both the common law rules of construction and interpretive rule in Section 12 operate to impose a territorial restriction on one or more of the generally worded terms in statute. Wasn't dealt with this judgment. Should be a subsequent hearing, but I'm unsure if it will proceed given the ban expires on Saturday. Yeah, that's right, Poppy. I wouldn't bother. But, yeah. But that's just me. Accordingly, in the present case, it is necessary to read the words of Section 4773B as though it read requirements that restrict or prevent movement of persons, goods, or conveyances in or between specified places in and of the Commonwealth. It is therefore presumptive if it does not apply extraterritorially. So what if they extend it, Bo? Then it's going to get interesting. Right, if you remember right back in the last, when we're looking at the affidavit, it did say that there was a review set, just that the government or the department was going to review the decision before it was due to be repealed. So they'll be preparing a report for the minister. But Poppy said it's going to be very politically unpopular and there's going to be a lecture. Well, then we'll see the constitutional argument play out. Yes, I'd say that that's what will happen if it gets extended. Yeah. So there is no contrary statutory indication that any part of so section 55, this is a case in which useful and clear legislative guidance is given as to the territorial reach of the Act. In the present case, the drafters have turned their mind to the extraterritorial reach of the Act and determined not to include such a reference in respect to section 477. The clearest express references to the extraterritorial operation of the Act is found in Chapter 11, Part 3, Cost Recovery, where it is expressively stated in Section 614, this part extends to Act submissions, matters and things outside Australia Territory. No indication is found in Chapter 8 in respect of 477. Notably, Section 30 suggests Parliament turned its mind to expressively limit the operation of the Act in other respects not presently relevant. Section 30 expressively provides the Act does not apply to the extent of its application and would be inconsistent with the existence of rights of foreign aircrafts or vessels. in accordance with the United Nations Convention of the Law of the Sea, above or in the territorial sea of Australia, the exclusive economic zone, or the waters of the continental shelf. There is nothing in the Act, true, but the presumption that Section 477 is intended to authorise a determination with effect only within the Commonwealth. But India's in the Commonwealth, isn't it? I think India is part of the Commonwealth. There is therefore no statutory authorisation in Section 477 in as far as the determination operates extraterritorially. This conclusion once again informs the breadth of Section 4771. That being said, determination made exceeds the power granted by 477. Maybe the whole thing was far to get ahead of the game because it felt it would be extended. Maybe both. Maybe it's a very clever legal thing. It's just with the events of the last few days. I'm just wondering whether they're not going to consider extending it, or they're going to need to probably look at the extension of quarantine. So the principle of legality. For the reasons outlined above, the applicant submits that the weight of the High Court authority plainly supports the conclusion that a right of citizens to re-enter their country of citizenship exists as a fundamental common law right in Australia. Such a right is not to be infringed except unless Parliament has determined by clear words or necessary implication that this may occur. In the present case, the Act does not reveal that Parliament so intended. As such, to the extent that determination seeks to deny citizens the right of re-entry is ultra vires as falling outside the grant of statutory authority. The grounds proceeds on an assumption, without prejudice or admission to any later hearing on prayer 4 of the originating application, that the Commonwealth Parliament has legislative power to abrogate the right to re-enter if it has chosen to do so. The applicant's case is that he has not acted to abrogate the right. It is a well-settled principle that the statutory construction that common law rights are to be regarded as abrogated by statute only by the use of language which manifests a clear intention to do so. What will suffice to demonstrate such intent as a matter of irresistible clearness is not a low standard. Any purported restriction must perspiciously expressed and strictly construed. In the absence of express and unambiguous words, what must be shown is that the legislation would be inoperative, meaningless, or wholly frustrated unless the right were affected, and so the intent to abrogate arises by necessary implication. The principle applies not only to the fundamental rights, but to the fundamental freedoms, immunities, principles, and is reflective of the common law as the ultimate constitutional foundation in Australia. It constrains both parliamentary legislation, creating a power to make delegated legislation, and the delegated legislation itself. Thank you, Poppy. Beyond the scope of the legislation doesn't address the right of AU citizens to return, so it can't be used to govern the right of AU citizens to return. Thank you. See? And that's essentially that. I think that's their argument, isn't it? That they've overstepped their power. For over a century now, the High Court now has recognised and subsequently re-endorsed the existence of a fundamental common law right of citizens to re-enter their country of citizenship. Indeed, the uncontroversial existence of such a right has been recognised by the authors of Hesford and Prince Interpretation 2020. Therefore, and they're described as a freedom of movement, which is presumed a statute does not interfere with. Has the government done much to change quarantine procedures for the wave? No, Bo, they haven't. Although it has been expressed with varying terminology over time, the foundational principle is the recognition that concepts of nationhood and citizenship rest on there being reciprocal obligations and rights between the states and nations. The right first found expression in Potter and Minahan, a decision concerning the meaning of the term immigrant as it appeared in the Immigration Restriction Act, and the boundaries of legislation power to make laws with respect to immigration as conferred by Section 51 of the Constitution. Chief Justice Griffin described the division of human beings into communities as an elementary part of the concept of human society, and in this regard recognised that English common law had held that an alien has no right to enter a country of which he is not a national. His Honour concluded, in turn, that since every individual must be entitled to enter some community, there must be at least one part of the world to which every human being, not an outlaw, can claim the right to entry where he sees fit. So fundamental did His Honour regard this concept to be that it was stated to be self-evident and need not the support of authority. In Potter, Justice Spartan likewise described the right of ingress, egress and sojourn as birthright, and doubted the Constitution could grant the government the right to prohibit the entry of those who are subjects. So did Justice O'Connor regard it as beyond serious controversy that an Australian could remain in, depart from or re-enter Australia as and when he sees fit. In an early reflection of the principle of legality, His Honour further stated that it must be assumed that the legislator did not intend to deprive any Australian-born member of the Australian community of the right after absence to re-enter Australia, unless it has so enacted by express terms, necessary implication. If I was travelling abroad and I saw what was happening in the world, I wouldn't have waited. I would have been on the plane. I would have had my bags packed. Well, there's a lot of people in Australia that feel that way. The community is quite mixed about it, actually. Yeah. The right and enter subsequently found expression in the joint decision of Chief Justice Mason and Justices Wilson, Brennan, Dean, Dawson, Toohey and Galdron in Air Caledonian International versus the Commonwealth. The court there was tasked with considering the validity of the law which imposed an arrival fee on all incoming passengers of overseas flights in order to clear immigration. Their honours in considering whether the fee constituted a tax or a charge or licence, and thus was beyond the head of Commonwealth legislative power, placed significance in the fact that the fee was imposed on both citizens and non-citizens alike. Their honours in turn held that the right of Australian citizens to enter the country is not qualified by any law imposing the need to obtain a licence or clearance from the executive. That being so, no service could be said to have been rendered to the citizen they were entitled to enter, by right to enter. More recently, the essential link between citizenship and the right of abode has been relied upon by the High Court in construing the concepts of citizen and alien as they appear in sections 54 and 51 of the Constitution. In re Canavan, the court, Bell, Gagler, Keane, Nettle, Gordon, Endelman regarded as determinative the existence or not of a person's right of abode, said to include the right to enter and reside in the country of nationality. In concluding whether that person was a citizen of a country in loving the Commonwealth, each of the justices, Gagler, Nettle, Gordon, and Endelman, in separate judgments, reasoned that the right to enter was a relevant point of distinction between a citizen and an alien. Notably, both Justice Gagler and Justice Edelman placed reliance on the High Court's earlier decision in Potter to conclude that there was a fundamental or absolute and unqualified right of a citizen to enter the country of citizenship. Recognition of the fundamental common law right of entry may be found by numerous decisions in the court, most particularly in the contents of migration law. By way of example, Minister of Immigration, Multicultural Affairs and Citizenship, His Honour Justice Flick had regard to the international recognition of a right of an individual of a country to enter a country which they are a citizen, as contained in Art 12 of the International Covenant on Civil and Political Rights. His Honour traced that right. Hey, yay, hey. I know we got migration law now, Poppy. His Honour traced that right to the long-established common law position that every Englishman may claim a right to abode in his own country as long as he pleases and not be driven from it unless sentenced by law. Such a right has likewise been recognised by Justice Perry and Justice Bromwich. The applicant submits that the weight of the authority binding this court, if not as ratio, then at least seriously considered dicta, is consistent with the existence of a common law right of citizens to re-enter their country as an incident of citizenship which cannot be abrogated or restricted except by the provided by the principle of legality. So remember, they were arguing that because he was a citizen, he should be able to return. And so that's what they're arguing. That being so, the question then is whether the Act reveals by clear words or necessary implication an intention to displace the presumption that there were no inferences with this right of re-entry and or an intention to grant executive power to make a determination which would abrogate that common law right. The delegated legislation must, in this regard, give way to the primary legislation. It is only if the primary legislation provides clear authority for the delegated legislation to overrule the common law right that this can occur. Thus, whilst the determination in terms plainly seeks to deny all persons, citizens and non-citizens alike entry into Australia, it may only validly do so if the Act rebuts the presumptions that all citizens' rights of entry will not be impinged. Nowhere in sections 477 of the Act, or indeed Chapter 8 more generally, is there to be found express words abrogating the common law right of re-entry, purporting to exercise the executive to make determinations which could have effect. If anyone's wondering why it's versus S, it's because some cases, notably refugees, give rise to privacy concerns where people may face pay clash in home country if it's public they applied for asylum. Right. Well, that's interesting, isn't it? So is that what they're trying? So that's what they're arguing, is it? Oh, SZIHU. Right. So they use, is it like a pseudonym? I don't know how they wouldn't extend with what's been happening. It's not going to get better. To the contrary, the examples contained within section 4773 as to the type of requirements which the minister is empowered to make are consistent with the recognition of and protection of the right of entry. In particular, section 4773A, as framed, does not envisage a large requirement being made which would prevent persons entering Australia, and its highest envisages a requirement being imposed on such entries, such as, for example, the need to quarantine after arrival. This may be contrasted with section 4773B, which is outlined only governs restrictions within territorial bounds of Australia, where the word prevent was included. And general power of quarantine is not to be equated with a general power of exclusion capable of being applied to citizens. I have to say, Poppy Seeds, I always wondered why yet there was a whole series of letters. It's just like a 5-letter pseudonym. A general power of so viewed, there is a plain intention by legislature to allow restraints on movements between places within Australia, but not corresponding intentions to prevent entry of citizens into the country. This deliberate legislative choice to distinguish the powers available to the minister reinforces the presumption that the citizen's right of entry was not intended to be abrogated. The effective operation of 477 in Chapter 8 does not otherwise depend on it being inferred that the legislator intended to deny citizens that right. Despite this, the clear effect of the determination, which when read with the Act is an infringement that the common law right by legislating that a citizen must not enter Australian territory and creating a criminal offence should a citizen attempt to contravene the determination by entering Australia. The determination thus seeks to do what the Act has not contemplated would be done. By reasons of the above, the court ought to therefore to conclude that 1, there exists the common law right of re-entry of citizens. 2, the Act does not itself seek to abrogate the common law right nor empower the minister to issue determinations which would abrogate it. 3, notwithstanding 2, the determination seeks to abrogate the common law right by mandating that all persons, including citizens, must not enter Australia. And 4, therefore, the determination is ultra-vires by falling outside the statutory authority which was granted by the minister by the Act. And then they're the people that wrote it. There's notice of filing. That was really long, but that was their argument. So that was their submissions. So then we've got a couple more, and we've got the respondent submissions as well. So then we've got, I'm just looking at the dates, the 7th. So then we've got this one. This is Jonathan Charles Hutton. So it says, I, Jonathan Charles Hutton, I'm an AGS lawyer within the meaning of the Judicial Act, and I have carriage on this matter. On 9th of May, I visited the media section of the website of the Prime Minister of Australia. I downloaded 3 documents. I downloaded the PDF version of the media release titled Resumption of Indian Repatriation Flights to Howard Springs, dated 7th of May. I now produced and shown to me marked JCH1, a true copy of the PDF media release I downloaded, which was titled Resumption of Indian Repatriation Flights to Howard Springs. I also downloaded a PDF version of a media statement entitled National Cabinet, now produced and shown to me marked JCH, is a true copy of the PDF statement which I've downloaded. So this is saying that this is here's the Australian government solicitor. So this is the government now. I downloaded a PDF version of the transcript titled Press Conference, and now produced and shown to me a true copy of the transcript press conference. So again, the witness. Signed. So here's the media release. So it's saying that the government chartered repatriation flights to the Centre for National Resilience at Howard Springs for Australians returning from India will resume on May 15th after the completion of the current temporary ban on re-entry. The Morrison and Gunner governments confirmed today. Since the pause on flights from India commenced, there has been a substantial reduction in COVID-19 positive cases originating from India. The National Security Committee of Cabinet was advised yesterday that the pause was working and that this would allow repatriation flights to resume after May 15. Temporary ban will remain in place until that time. The number of COVID positive cases in the Howard Springs has fallen to 21 from more than 50 cases a week ago, and the positive cases associated with previous facilitated flights from India are on track to reach 0 by the 14th of May. Repatriation flights into Howard Springs will resume on 15th of May with 1 flight per 7 to 9 days, with an estimated 1,000 Australians returning by the end of June. Vulnerable Australians will be prioritised on this flight. An initial repatriation flight to Darwin will leave India on May 15th. 2 further repatriation flights to Northern Territory from India will be scheduled during May. Prime Minister Scott Morrison said the flight pause had given the quarantine system a space to operate safely and protect Australians from COVID-19 pandemic, with the travel pause remaining until May 15 with no changes. And so this goes on, closing and the use of quarantine has protected the health of all Australians during the pandemic. I've written to state and territory leaders to invite their participation in receiving direct repatriation flights from India over the coming weeks to further assist efforts in Howard Springs. Now, Howard Springs is the only federal government-run quarantine facility. So this is... All right, so that was from the Prime Minister's office. Then we've got this one. This is a media statement on the National Cabinet. National Cabinet met today, discussed COVID-19's response. There have been 29,897 confirmed cases in Australia, and sadly 910 people have died, and more than 17.1 million tests have been undertaken. So then they've gone on and talked about internationally. I'm not sure about that answer. I don't know. I think, yeah, I can't answer that, Jean. So National Cabinet returned to monthly meetings, so June the 4th. So then there's, again, that's another one about the national flights. National Cabinet noted the New South Wales, Victorian and Queensland governments offered to accept further facilitated flights from India in May. And South Australia will consider arrangements over the next 2 weeks. Post-May, 15th of May, transit points into Australia will be monitored carefully to ensure that positive case numbers remain at manageable levels. In particular, the Commonwealth Government will work with the Sri Lankan government to monitor the situation in Sri Lanka and whether further measures need to be in place. We'll also consider tightening Australian Border Force outbound travel restrictions for Australians travelling overseas and continue restrictions in place with respect to applications for travel to high-risk countries. National Cabinet agreed to vaccinate essential outbound Australian travellers with ABF travel exemption approvals. These include people travelling in response to COVID-19 outbreak, including in the Pacific, urgent medical treatment, national interest, critical industries, business, compassionate and compelling grounds, urgent and unavoidable business. National Cabinet noted that future agreements on cap flights between jurisdictions and the Commonwealth will be discussed. So the next one is, so this is a transcript of the press conference that the Prime Minister did. So they're saying we anticipate there will be people on board that flight who will already be in Malaysia for a period of 2 weeks. But I want to thank Australia, West Australia will be considering, and of course into Tasmania there's no opportunity for that nor in the ACT. So again, this was his press conference, the transcript of his press conference. Professor Kelly talks about the vaccinations. And then some questions. So if you come, you've got to go, well, it depends where you come. So if you end up in the Northern Territory, you end up at Howard Springs. If you enter one of the other states, you do hotel quarantine. If you come back with a positive test, you then get sent to a Medi hotel where all the positive cases go. Given that those who have COVID-19 cannot be repatriated, are you comfortable leaving some of your vulnerable people in India? So this is the question and answer. Would you consider another federally run quarantine facility? They should. I reckon they've got a capacity of 2,000 people now in the Howard Springs. So I'm not a medical officer, like I'm not a medical professional, so I can only talk about what I think. So that was the affidavit. So then they've replied to that. It was a busy day Monday. There was documents flying everywhere. 64 pages. Okay, I'm the solicitor for the applicant making these proceedings. I'm authorised to make this affidavit on the applicant's behalf. As part of his originating process, I have previously affirmed 2 other affidavits. I'm informed by the applicant that, and believed on the 8th of May, the applicant conducted searches on the internet and on the website Travelicity. The applicant obtained the following search results. There are several flights per day on 10th of May, 11th of May, 12th of May from BLR, Bangalore to Doha, either directly or indirectly. Most are operated by domestic Indian carriers. These are regularly scheduled flights on the 10th of May, 11th of May, 12th of May from India to Maldives. Over yesterday and today, I have searched Google Flights and identified that each on the 10th of May, 11th of May, 12th of May, there are either direct or indirect flights from Bengaluru to Doha. Over yesterday and today, I have searched Google Flights and identified on each of the 10th May, 11th May, 12th of May, there are either direct or indirect flights from Bengaluru to Maldives. A copy of these search rights. Over yesterday and today, I searched Google Flights and identified on each of the 10th, 11th, or 12th, there are either direct flights or indirect flights to Bengaluru to Abu Dhabi. Based on the following, that appears not re-silent, notwithstanding the circular to the Office of the Director of Civil Aviation, Government India, dated 30th of April 2021. Certain international passenger flights have been able to depart India. On Sunday, 9th of May, Etihad flight EY217 departing Bengaluru arrived in Abu Dhabi at 4:17. A screenshot of the international airport's website Also on the 9th of May, Qatar flight arrived at Doha. I've also identified a non-exhaustive list basis of the following flights for the applicant to travel to Australia. Air India flight, 10th of May, 11th of May. Etihad flight to Abu Dhabi, arriving in Melbourne at 9:15, 9:55 on the 12th of May. Hang on, that's during the travel ban. Qatar to Doha, so he's showing the 11th of May, connecting to Doha on the 12th of May. Qatar flight from Doha on the 12th of May and arriving at 15:55 in Melbourne on the 13th of May. I was informed by the applicant and believe that he would like to be able to book the flights identified in paragraphs 9. He has not booked his flights identified in paragraph 9. He's concerned about the effect of determination that he will be committing some offence if he boards any of the flights. He does not want to risk losing the cost of the airfares if he cannot fly. So in correspondence at 6:57 p.m. on Friday the 7th of May 2021, I received a letter from the lawyers of the respondents. So it's correspondence back. I have this morning accessed the website. The website contains a transcript of the interview between Chief Medical Officer and Laura Jade of Sky News. All right. So there we go. So now he's showing all the Google flights. So what he's showing is that he could actually get to Melbourne during that time period, which I don't, yeah, I find to be really quite bizarre. This is just all flights here. Yeah, he's showing all flight details here, man here. All right. I believe the purpose of this is to show that he would be able to travel if not for this ban, which they're saying is wonderful. Pointless to complain about a ban if there were no flights anyway. Well, that's true. Good point. So he's saying, but I thought they had, they were supposed to block that loophole because they discovered the cricketers, Australian cricketers, actually used that loophole. I'm just quickly going through here. So this is so it says refer to matter. We write to you to put you on notice. The minister may submit that your client does not have a standing to bring this proceeding on the basis that your client has not provided enough information, evidence to support a real sufficient interest in relief sought. Submissions on standing, if advanced, will be included in the minister's written submissions, which will be provided to you on Monday morning. Okay, can you please advise on what basis your client may challenge our client's standing? Monday morning would be far too late to be notified on any such challenge and could well waste the court's time. If there are valid objections to standing or the evidence, it may be that issues can be resolved prior to the hearing. Okay, so this is the correspondent. They made it. You can't come to AU if you've been in India, regardless of where you're staying. I think it was originally just from India's. Yeah, well, that's how the cricketers got through. So there's some correspondence here. If in the event, it should be clear from my client's present evidence that he has both previously booked to travel to Australia and now wishes to return to Australia and would be willing to travel by a third country to do so, but is at the peril of criminal sanction to do so. And then this is the transcript. Yeah, they are doing that. There is a loophole. I mean, the cricketers that are in India now, they're all actually in the Maldives at the moment. So then we've got the submissions here by the respondents. This is 30 pages. Wow. All right. So we've got the applicant seeks declarations is invalid. The contention should not be accepted. The applicant lacks standing to seek relief sought in respect of grounds 1 and 2. The determination is amply supported by the broad power conferred on the Health Minister. He's a non-delegable power to determine any requirement the Minister is satisfied necessary to prevent or control entry of COVID-19 into Australia or prevent, control its emergence, establishment or spread. The applicant seeks to superimpose into S471 restrictions are not found in the statutory text and are inconsistent with the emergency context in which the powers are conferred. In doing so, the applicant asks the court to recalibrate the balance that the Parliament has carefully struck. None of that is altered by the principle of legality. So the Minister contends that the applicant lacks standing with the consequence that the declarations on grounds 1 and 2 must be refused. It is often said within federal jurisdictions, questions of standing are subsumed within the constitutional requirement that there be a matter, but not suggest that the requirements are interchangeable. As Gamo J. more fully explained in Truth About Motorways, again, we've got footnotes. The notion of standing is an implicit or explicit element in term matter through Chapter 3, identifying sufficiency of the connection between the moving party and the subject matter of the litigation. However, it would be an error to attribute this notion to a fixed constitutionally mandated content across the spectrum of chapter CH3. As the explanation suggests, the content of standing requirement varies depending on the relief that is sought. Relevantly, for present purposes, the authorities established that where there is a declaration is sought as a relief or part of the relief that will resolve a matter, the availability of such relief turns principally upon whether the applicant has a real or insufficient interest in obtaining the relief. That moving party may feel a real sense of grievance or injustice does not suffice. Rather, a person does not have a special interest unless he is likely to gain some advantage other than the satisfaction of righting a wrong, upholding a principle, or winning a contest. If his action succeeds, or to suffer some disadvantage other than a sense of grievance or a debt for costs if his actions fail, that requirement is not satisfied because a person merely would be positioned in a series of contingencies materialised. And again, they've just quoted a whole pile of law. So this point is well illustrated by the reasoning of Gibbs J. in University of New South Wales versus Morehouse. Although his Honour's observations were made in the course of considering the discretion to refuse relief, they were subsequently cited in Ainsworth versus Criminal Justice Commission in a discussion of the boundaries of judicial power. Justice Gibbs said that the case of an owner of copyright seeking to assert his or her rights, a declaration should not be a general rule be made unless it established either that an actual infringement has occurred or that the defendant intends to take action that will amount to an infringement. His Honour also referred to many examples of cases in which a declaration had been refused as regards circumstances that have not occurred and might never happen. Justice Gibbs' observations about circumstances which had not occurred and might never occur aptly describes the position of the applicant. The Prime Minister has announced that the travel pause will not be renewed beyond the current determination. Affidavit of Jonathan Charles Hutton affirmed 9th of May. The Prime Minister's media release states that the medical advice provided to the Minister for Health is that it will be safe to remove the determination. That announcement is a statement at the highest level of the Commonwealth Executive Government that upon the repeal of the determination, no similar instrument will be put in its place and therefore expire at the end of Friday, 4 days after the hearing in this matter. The evidence before the court as to the applicant's interest given by his solicitor does not suggest that he will be relevantly affected by the determination in that very limited time frame. The effect of this evidence is, first, all scheduled international passenger services to and from India are suspended until 11:59 from the 31st of May 2021, more than 2 weeks after the determination will cease to effect. Second, the applicant had considered travelling to Pakistan sometime after the Prime Minister's announcement of the 27th of April 2021 in order to fly from Pakistan to Australia. He does not say that he has progressed that hypothetically possibility beyond its consideration, or even that his consideration that a possibility is ongoing. He does not suggest that he has any immediate concrete plans to travel to Pakistan, let alone in the next 4 days, or that concluding his affairs in India and travelling to Pakistan is a practically possibility within that short time frame. He doesn't suggest that he has obtained a relevant visa or other permission to travel to Pakistan to the extent that is required. Nor does he suggest that he's taken any steps to secure a flight from Pakistan to Australia, or that would be even a realistic possibility. Noting also his solicitor's evidence of 14 to 15 about the difficulties the applicant experienced in securing a flight to Australia from India. Third, the applicant does not adduce evidence that would demonstrate that all of those many steps are in fact practically possible within the next 4 days, but that the determination forecloses their pursuit by requiring the observance of particular norms to which are attached liability to the prosecution and subsequent punishment, i.e. the defects of crime. So Michelle says, if someone returns now, they face 2 weeks hotel quarantine at their own expense, COVID tests about 3 times. All these have to be negative. They also have a COVID test about 4 weeks after, and that's how they've picked up this other guy. In short, the potential application of the determination of the applicant in the next 4 days rests upon a series of contingencies that have not come to pass and are, it may be inferred, highly unlikely to come to pass in the narrow window of time remaining. In those circumstances, there is no satisfactory evidence before the court that would suggest the applicant has any real or sufficient interest in obtaining the relief he sought. The applicant bears the onus of demonstrating their interest. He has failed to do so. In federal jurisdiction, the consequence is that the relief must be refused. It is not a matter of discretion. The minister has advised the applicant that he proposed to make submissions broadly along the lines as made. In response, the applicant indicated that should the minister maintain his position, the applicant may seek to adduce further evidence to address the minister's concern. The minister has no objection to that course. The court cannot grant relief unless it is satisfied the applicant has standing, again, not being discretionary matter in federal jurisdiction. Accordingly, the minister proposes that the applicant be granted leave to adduce further evidence on the point, and that, if necessary, the court invite further submissions from the parties on that issue. Of course, it would not be necessary to consider that issue if the court determined to dismiss the application. And that's what happened. The court dismissed the application. The High Court has said that the notion that is standing is a threshold issue does not prevent the court in its discretion from proceeding immediately to an examination of merit. That is what the minister proposes here. So now it's talking about the legislation, special powers under the biosecurity emergency, which we've gone through. And there's that, yeah. Any requirement means what it says. Contrary to what is said at AS44, the term any requirement makes plain that the power conferred by S44 was not intended to be limited by the example given at S44.3. The reason for that is obvious. The matters to which the minister may need to respond involving an emergency with the characteristics identified in S4751 may require novel execution action, not readily specified in advance. So, purposive powers. So now they're talking about the powers of that. I don't know if they extend your passports. They are expensive, and the kids' ones especially in the last 5 years. And we are, oh no, really? I think they should. Well, yeah, there's no overseas travel until 2022. So So the width of examples. So this is all the legal stuff. Yeah, I'm going to go through some of this. I'm just going to, because my voice is actually going, require that the minister be satisfied determination is necessary. So they go through that, how the decision is made. It's actually like very easy to read. There. So now we're section 477. My Jetstar voucher better get extended again. I will go to Hawaii eventually. So this is on lots of case law here. In the context of constitutionally implied freedom of political communication, a court will inquire into whether a measure is necessary by asking whether there is an obvious and compelling alternative which is equally practical and available, which would result in a significantly lesser burden than the unimplied freedom. So again, more argument here. I'm sorry, I was going to read it all, but my voice is starting to go. So I just want to get to the other stuff. So I apologise to the Minister of Health for not reading all of his submissions. And so now they're going through the stuff that was in the submission, that there was likely to be, that the integrity of hotel quarantine. Ground 1 alleges that the Health Minister failed to have regard or consider properly statutory preconditions to the exercise of power. So evidence that the Minister read and considered the material before him. First, and somewhat remarkably, appears to be contended that the Minister has failed to adduce sufficient evidence to demonstrate that he read or engaged with the briefing materials, AS3, that inverts the onus of proof, which apparently the applicant plainly bears in the absence of evidence to the contrary. It is to be that the Minister read the ministerial submissions and its accompanying attachments. Indeed, the applicant accepts the proposition at AS30. Those materials appear in MB8. The version of the material submission was signed by the Minister is reproduced. So they were trying to say that he hadn't read it. That was one of the arguments. The oblique suggestion that the Minister should have spent more than one day reviewing the ministerial submission and its attachments is surprising in light of the emergency contexts in which the power is enlivened and the relatively short length of submission. It also ignores the fact the Minister was entitled to have regard to that considered opinion of the CMO, a matter which is obviously contemplated by legislation of this kind. That is especially so given the CMO is assigned the particular functions as Director of Human Biosecurity. Merits of the Minister's reasoning. It says the applicant's reliance is strained. The case, which concerned a review of 130 pages in 11 minutes, plainly fails to be distinguished. The main point sought, the Minister should have had regard to certain matters. So they've done a bit of underlining. I'm just doing this slowly for you. Minister's state of satisfaction. So they're now showing why the Minister was satisfied. He had to sign for it as well. So extraterritorially. But the new and more need to be treated as if they were changes. Yes. Illegality. Relevant rights. Defense of some of the arguments. As I said, I'm sorry, my voice is going. So I want to. So what it all means, the principle of legality at most concerned can have limited application to the construction of legislation, which has amongst its objects the abrogation of or curtailment of particular right, freedom, or immunity in respect of which the principle is sought to be invoked. That is plainly the case here. For the reasons given in paragraphs 84 to 93 above, the scheme established by Chapter 8 clearly contemplates the requirements imposed under S4471 and may include preventing persons, including citizens, from entering Australia. For obstacle, there is a further separate difficulty with the applicant's argument. Although not clearly acknowledged, the necessary consequence of the argument must be read into a limitation to the effect that the general power therefore conferred does not include a power to prevent entry into Australia of citizens, but inferred does include a power to exclude aliens. That must be so because the principle of legality could have nothing to say as to the position of aliens. It is clear in that regard that an alien enjoys no right, whether fundamental, important, or otherwise, to be in Australia and for part of its community. So here you go. For the foregoing reasons, the original application should be dismissed with costs. In the contrary to respondent submission, the court finds that the application has standing. The relief sought on grounds 1 and 2, the originating application should be refused with costs. So that was theirs. Okay. So then we had, so that was submissions. Then we had another one from Michael David Bradley. Oh, no, that was that one. Sorry, I've done that one. Sorry, we're getting near the end. So we've got submissions, restanding. These are 9 pages. Okay, so on Friday evening, after receiving the applicant's submission and despite 2 earlier directions hearing, the minister raised for a first time a concern about standing for applicant or the existence of a federal matter. At 9:05 this morning, the applicant received the minister's submissions. Those submissions appear to challenge standing. It is not clear whether the minister concedes that the existence of a federal matter, but RS4 notes that the questions are closely related. In any event, questions of standing matter and hypothetical issue cannot be separated in watertight compartments. The court is seized of a justiciable controversial because the applicant, Mr. Newman, is in India and would like to come home, but as it presently stands by law, by means of determination, is directing him to avoid taking the course of conduct for fear of criminal sanction. Considering whether a matter exists, the court attention ought to be focused not upon testing just how willing the applicant is to break the law, but instead the court must look to absolute terms in which the determination speaks to the applicant, because he has been in India, distant from all others in the Australian community who have not, and purports to deprive him of his liberty to re-enter should he do so. Briefly stated, this submission first answers the correct factual matters challenged by reference to the 3rd Bradley affidavit served this morning. Second, this submission reviews various of the authorities that explains the applicant. So we've got factual matters. So apparently he's been looking for flights. There are flights available to where he could exit India for a 3rd country and provide an onward flight. Despite whatever the purported effort of the Indian government's ban on flights, there are nonetheless still flights leaving India for 3rd countries. The applicant would like to be able to book flights, but remains concerned at committing an offence. First, in the face of those documents, they state they're subject to an exception that, however, international scheduled flights may be allowed on selected routes by the competent authority on the case-by-case basis. Second, in any event, the affidavit makes clear that the flights are leaving India, that it is a clear reason the applicant has not taken further steps because he's concerned about breaking the law. The court's originating regional jurisdiction in the centre of its authority to decide the present proceedings is derived from Section 39B(1)(a) of the Judiciary Act, conferring upon the Federal Court of Australia authority to decide any matter arising from any laws made under Parliament. So they go on through that. The applicant submits that the court should address the substance of the claim at the same time addressing the standing and its reasons, given it is unlikely the legislation will otherwise be challenged. So we've got more law here. And so there's law arguments at the moment in here. I'm just trying to find something where they relate it back. In the present case, the applicant clearly tends to take action to enter Australia and he faces the risk of being subject to the legal process. This is sufficient to ground standing. To demonstrate the concreteness of the present case another way, in addition to seeking a declaration as to invalidity of the determination, the applicant would be entitled to seek a declaration that his arrival into Australia on a particular date is not in breach of the Biosecurity Act or any other delegated legislation made under the Act. The court, in its present case, is dealing with a sufficiently concrete state of affairs to ground the applicant's standing. So there was that one. So I think we've looked at them all. Now, what I found really interesting is I think he's also got an English passport. So, right, so this is now this is the order that was made. So, pursuant to 17.4 of the Federal Court of Australia Act, the extent that any legislation, order or other instrument operates to limit or exclude members of the public from being able to attend the hearing of these proceedings, the sitting of court continue notwithstanding the inability of the public to be physically present. Unless the court otherwise orders, no persons being a member of the public who is observing the hearing of the proceeding by accessing any audio or video link, including by link to the Cisco platform, may make any audio or video recording or photograph of the hearing, any part, participate or interrupt the hearing, provided that nothing in this order shall prevent any person based on what he has seen or heard during hearing making his or her own notes of recording, publishing a fair report of the proceedings. The court notes that the contravention of Order 2 may constitute a contempt of court and be punishable by imprisonment and or fine or cess question of property. Prayers 1 and 2 of the originating application be dismissed. And that's it. That's it. That's what the judge ordered. That's all we've got. That's all that was made. all of this. And the last 1 hour and 47 minutes for that, for one word, the case be dismissed. So it's saying that's been part heard. So I don't know whether there's any more to come. So it's so it's been dismissed that part's been dismissed. So the part 1 and 2. So there you go. The government, the court upheld that the government ban remains. As I said, it expires on Saturday. So we just now wait and see what's going to happen. And it looks like that they are not going to extend it beyond that the 15th is the day that it finishes. Oh, thank you, Lee. I know. I'm sorry I cut some of it short, but I'm also I've got to also be aware that I'm not feeling the greatest either. So thank you, Dee. So anyway, tell me what you think about it all. I mean, as I said, I know that the US has bans on India to fly other than for citizens and residents. I'm not sure about the UK, but please let me know, what the rules are in your part of the world, and do you think that the ban was a good idea, bad idea? Whether you think you would extend it. But as I said, at this stage, the court has upheld the ruling, and it looks like it's going to remain in place. So I'm going to head off now. So thank you all for joining me for this little bit of a different case, and I will catch you later. on.